Good morning, one and all. As Vincent had indicated, I'm Brent Oltheis from Hunter Litigation Chambers, and I will be the moderator of today's panel. I thought I would begin just by briefly introducing the topic and then introducing you to our three panelists this morning. And then we will be speaking in order that you see them here on the table. But I wanted to speak a little bit at the outset regarding latest developments on legal privilege and FOI. Primarily, I think what you're going to be hearing about from our speakers is solicitor-client privilege, that particular category of legal privilege. And as everybody, or most of the people in the audience at least today, will know, the courts over the last, really over the last 20 years, have expanded the scope of solicitor-client privilege greatly. And it is now well established that solicitor-client privilege, at least, is no longer simply a rule of evidence, but it touches upon, as the courts have recognized, a fundamental right. And a fundamental right of the citizenry, of the populace, that is based upon a very important premise. And that premise is, as has been recognized in a number of cases by the Supreme Court of Canada, that people with legal problems should be encouraged through the provision of some zone of special privacy to make a clean breast of the facts when they're approaching a lawyer for legal advice to help prosecute or extricate themselves from that legal problem. And so it's because of this broader policy goal, of course, that we have solicitor-client privilege recognized. And as I've indicated, over the last 20 years, we've had the courts giving increasing protection to solicitor-client privilege. Now, the fervor with which the courts have pursued this goal has certainly been the subject of some controversy and some comments that are critical of the court's development. You'll hear some people or some academics have written questioning whether privilege should be recognized in certain contexts. For instance, there are some who would question whether privilege ought to be recognized vis-a-vis governmental actors. There are others who would question whether privilege should be recognized vis-a-vis corporate actors. Is this really a fundamental individual right, or is it something that is properly recognized when a corporation is the party seeking the legal advice? And these are some of the topics that are really the points of pressure today when it comes to solicitor-client privilege. Of course, on the other side of all those arguments, there are people who would talk about chilling effects. If you remove privilege from certain categories of clients, then perhaps you will find that legal advisors are less willing to provide that independent and free advice to the clients. From a lawyer's perspective, we lawyers are obviously regulated, and we're told that it is our duty to assert privilege on a client's behalf. The privilege belongs to the client. It does not belong to the lawyer, but it's the lawyer's job to ascertain and to ensure that he or she is asserting privilege on the client's behalf. And the traditional view, at least, and this has been recognized again in a number of Supreme Court of Canada cases, is that when privilege is asserted, if there's a question about whether it's been asserted appropriately, it is the courts, and really the courts alone, traditionally, that are able to access the materials themselves to determine whether the privilege has been properly claimed. And there is obviously some controversy about that, particularly in the FOI realm, and we'll hear about that certainly from our panel today. There's a question about the extent to which commissioners and their delegates can look at documents and assist in that determination as to whether privilege from disclosure in an FOI context has been properly asserted. Most recently, there are two cases that I'm going to mention because I do expect that they will be the subject of some of the comments we're about to hear. The first is a Supreme Court of Canada decision from late last year. In November 2016, the court released its reasons in a case called Alberta Privacy Commissioner and the University of Calgary. And again, you'll hear about that case from the panelists who will be more suited and more equipped to speak about it in detail than I am. But the case generally is about the legislative standard that is required in order to abrogate privilege. So in other words, in order to make it clear that privilege does not stand as an exception what sort of language does the legislature have to use? And there was a split court in the Supreme Court of Canada as to whether the Alberta legislature had met that standard in the case before the court last November. The majority of the Supreme Court of Canada held that the legislature wasn't clear enough and that the general and sort of orthodox view of solicitor-client privilege as being sacrosanct had not been effectively touched by the legislature. They had left that untouched. More recently, there was a case called British Columbia and Lee, which touches on a couple of other issues. I don't want to speak about it in too much detail because the first person you're going to hear speaking today is actually a litigant, a respondent in that case in the Court of Appeal. But it does talk as well, or it does touch upon some of the emerging issues that I'd mentioned earlier in terms of scope of privilege and in terms of waiver. And so I'll leave Paul Doroshenko to speak about that. And he'll have, again, the unique role as a person well-versed in the area of law, but also a person who's litigating that particular case. So I'd like to introduce you to our panelists before I hand the mic over to Paul. Paul Doroshenko, the first speaker you're going to hear from, is a principal at Acumen Law. He practices criminal law. And again, just to set the stage for his connection to the Lee case, Paul, his firm, and some of the partners in his firm made an FOI request for information about some of the immediate roadside prohibition devices. And that was the genesis, or that was the seminal point leading to the Lee proceedings, which went first to the BC Supreme Court, and where his group met with success, and then was overturned in the Court of Appeal. I'll tell Paul, before I hand the mic to him, that the fact that the Court of Appeal judgment was rendered by my former partner should not dissuade him from being as critical as he wishes to be. The next speaker you're going to hear from is Michael Lucas. Michael's the manager of the Policy and Legal Services Department at the Law Society. Michael's an experienced lawyer. I noticed during my due diligence, Michael, and I hope you appreciate this as a real tribute, but I did notice that September 25th is your 30th anniversary at the bar. So we're very, very close. Congratulations for that. Michael's a frequent speaker at CPD events and is commonly speaking on topics related to the regulation of the practice of law. What we're going to hear from Michael today is really the intersection of that regulation and this issue of privilege and FOI. The third speaker we're going to hear from is Brad Weldon. Brad's the Director of Policy at the OIPC. He's been with the OIPC since 2011. Brad has a background prior to his time with the OIPC in employment and labor law, and that has, I suppose, really been the segue to his specialty with the OIPC in employer-employee privacy issues, emerging technology issues, and surveillance. And Brad, one of the more notable things that Brad has worked on was the investigation into the District of Saanich and its surveillance of employees. And I'm not sure if that's going to form part at all of his topic here today, but Brad will be the third speaker discussing this topic of privilege. So with that, I'll pass the mic over to Paul Doroshenko, who has prepared a speech and a PowerPoint for us.
Good morning, everyone. I thank the organizers of this event for inviting me. It's an honor, and it's an awkward situation for me because I can tell you I'm a drunk driving lawyer. I'm no expert in freedom of information, protection of privacy, or anything like that. We make a lot of freedom of information requests, but most of the time when I'm at a conference and I'm presenting something, I'm explaining how the police screw everything up and how badly they conduct impaired driving cases, and that's sort of more my thing. But unfortunately, in this case, I am a litigant, so I'm going to be talking about my experience in the AG and Lee case. I'm sorry, I already pressed that I'm going ahead too fast. And I've given it two titles. What you can hide by claiming solicitor-client confidentiality, or can you ever know if the administrative tribunal operates in accordance with the principles of natural justice? I gave it two titles because I was splitting my mind, but mostly I was thinking, and I'm glad to see the average age of this audience, I was thinking of the Rocky and Bullwinkle cartoons. And at the end of the Rocky and Bullwinkle cartoons, before it went to a commercial, it would always say, in our next episode, Bullwinkle bites the dust or Rocky shoots for the moon or something like that. So I kind of had these two ideas going through my mind as I was coming up with the title for it. But A.G. Lee is the Attorney General of British Columbia, and Kyla Lee, who is one of my colleagues, and that's the short form of it. And it's unfortunate for Kyla that it's her name in there, because after that it's also Paul Doroshenko Acumen Law Corporation, basically everybody else that was at my firm. But we make a lot of freedom of information requests because we deal with this particular tribunal at the Superintendent of Motor Vehicles office, and we deal with the police, and we have to collect information from those two different organizations. What we defend mostly are immediate roadside prohibitions. Now, most drinking driving cases in BC these days are dealt with by the police just at the roadside. They use a roadside breath tester. They submit a report to the Superintendent of Motor Vehicles office. It doesn't go to court. It's not a provincial court judge making the decision. And it's a problematic system in my mind for many reasons. Number one is you've got a tribunal that is empowered by the government to basically fulfill their legislative agenda. And the legislative agenda is to make a decision between the litigant, which is the person who's accused of whatever the offense is, but it's in this case, either blowing a fail on a roadside breath tester or refusing to provide a sample, and the government. So on the one hand, you've got the government, on the other hand, you've got the litigant, and you've got a government tribunal that's there to make this legislation happen, and they're the ones who are making the decision. So it's not like the residential tenancy branch where they've got a landlord on the one hand, they've got a tenant on the other hand, and then the government person is there, and it's very easy for them to say, look, we have no skin in the game. It's a different situation when you're dealing with this administrative tribunal. And if you had an administrative tribunal, well, if you had a case in provincial court and you're charged with refusing to provide a breath sample, and you're in provincial court and you finished making your submissions, and the judge then picked up the phone and phoned the Attorney General and said, what do I do? What do I do? We'd all be very concerned with that. I can tell you it doesn't happen, but we'd all be very concerned with that. But unfortunately, we don't have that sort of same protection when it comes to an administrative tribunal. And many things are going to, more and more things are going to administrative tribunals these days. If you think about, I keep thinking about ICBC driver services, because I have to go down to driver services every once in a while when one of my staff members can't go down. And I file for review for driving prohibitions for people. And I sit there at the counter, back at my seat, and I look at the counter, and everybody's life is laid bare there. You've got 20 people sitting waiting, and the other people who are standing up at the counter are having to give their secret password or their mother's maiden name and all of this stuff, and you're all within earshot sitting there at ICBC Driver Services. And it's quite upsetting. But when you do go to ICBC Driver Services, that person who's dealing with you is making decisions. They're decisions that could be judicially reviewed. They're acting sort of like a tribunal. You've lost your driver's license, for example. You show up, you've got your expired passport and your library card. And you go to that person, you say, well, I've lost my driver. I've got 2 pieces of ID here, but it's expired. And you make your submissions at that point to the person who is standing there, and they're going to make a decision. Or they're going to walk away and they're going to go talk to their supervisor. Now, you're making the submissions. Are you making the submissions to the decision maker? The supervisor is actually going to be the decision maker. You're just going to be informed of the decision. And that's acceptable in many contexts. Lots of times we're making the submissions to somebody who's going to speak to somebody else, and they're going to come back and they're going to speak to them about what's our policy. This is the policy. They're going to interpret policy. And they'll come back and you basically get informed by the person at the counter, but the decision maker is somebody else. You're not making your submissions to the decision maker, which would be a normal process and principles of natural justice. When it comes to the Superintendent of Motor Vehicles, you're making your submissions to an adjudicator, and you don't know what happens after that. So the deck is stacked against the applicant for a number of reasons when it comes to immediate roadside prohibitions. The onus is on the applicant to prove that they're innocent. At the same time, the disclosure is controlled by the police. So you can't get the disclosure from the police, but it's your obligation to prove your case. You got to prove your case 50% plus one. And the tribunal reverse engineers the decisions to uphold IRPs. I will tell you that is the most controversial statement that I make, probably. It is a upsetting thing for me as a lawyer, but the courts have recognized it. So a number of decisions have gone. What happens is a decision is rendered by the Superintendent of Motor Vehicles office, comes on your fax machine, you look at it, you're trying to figure out how the heck could they come to this conclusion. And you look through it and it looks like, oh, okay, well, they started with the presumption that your client was guilty. All right, well, that's a reverse onus. But then they basically did everything they possibly could to reject your client's evidence and to try and massage the police officer's evidence. The police officer's evidence is subject to no scrutiny whatsoever. Your client's evidence is rejected because there's an apostrophe missing that somehow changes the sentence. It's very upsetting, but this is something that the courts have recognized to some extent, not to the extent that we would like, but that we see reverse engineering. We also see unsupported factual findings. So in one case, Maudgill, the adjudicator at bar simply assumed accuracy and rearranged the facts to support that assumption. Basically the same concept of reverse engineering. In the Byron decision, I find that by assuming the facts necessary to uphold the IRP where evidence was lacking, the adjudicator's general decision-making process with regard to credibility and other relevant evidence was unfairly tainted. On this basis, I find the adjudicator's decision was unreasonable. So they subject the accused evidence to a different standard than they do the police, and they basically start with a presumption of innocence and work backwards. And the difficulty that we have in my office is that you conduct 14 of these hearings and get 14 decisions, and you can see what's going on. You can see the pattern. But how can you explain it? How often do you get the evidence that you can show something's not quite right here? You can run a decision that's an obvious one, like the 3 quotes that I've just provided, but it's not always as clear as that when you're getting the decision. You can see it from the pattern, but you can't run a judicial review, a petition of a pattern of cases. You get to go in there and you get to say, well, this is what the adjudicator did wrong in my particular case. And there's a presumption of regularity and a presumption of that everybody's doing everything right. So we know, as a result of whistleblowers and other things, that the tribunal gets legal advice. We know that. It's something that happens. The question is, how do you find out about whether or not they got legal advice? And is it legal advice that should be disclosed to an applicant for them to be able to decide whether or not they should be making submissions about the legal advice? So back to my circumstance with the person who's standing at the counter who's got their expired passport. That's basically a pure policy decision that a manager is going to make. You don't get the opportunity to make your submissions to the decision maker. But in a tribunal such as the Superintendent of Motor Vehicles, the Road Safety BC decision, it's held out as you making your submissions to the decision maker. They've got cute little cartoons that they put on YouTube where they show the adjudicator there with a stack of paper and then you at the other end making your submissions. But we know they get legal advice. The question is, how do you find out when it's happened? And I'm just giving you this because this is from a case called Bowie. We're going to get back to it. There's a catch-22. The catch-22 problem is, if disclosure of both the solicitation and the nature of the legal advice is not made, how can a person such as Mr. Bowie or his counsel determine whether any overstepping of boundaries has occurred? How can you know whether or not they've, what they're doing, what they're telling the adjudicator if you can't see it? So back to our particular case in AG and Lee. We make Freedom of Information requests to the RCMP, to police detachments for breathalyzer records, and to the Superintendent of Motor Vehicles to find out policies and all sorts of other things that are going on. We made an FOI, and I can tell you most of our FOIs don't come in the time period in the 30 days. In fact, I can't think of one that has. But every time they always claim that they need more time to go over the disclosure, to look at it, to figure out whether or not it's going to be disclosed to us. And so they took extra time, a couple of months, I think, before we got it. And we got the disclosure, and a lot of it was redacted, which we often see. Sometimes you're trying to glean why it was redacted, and you cannot figure out, for the life of you why it was, what would have mattered. Sometimes you can tell what the word was, but you can't figure out why they would have bothered to do that. But in any event, they took extra time to review it. It contained an email chain at the end, the last 19 pages. And that sounds like it's something tacked on that should have made us suspicious. It wasn't, because it was basically just everybody's one-line comment attached to the email. So there was the meat and the potatoes of it, but there was also just a bunch of garbage. But the meat and potatoes was an issue for us. And in this, it said that it was privileged, confidential material. And we see that regularly in Freedom of Information requests. They're claiming privileged, confidential material on everything, but lots of the times we still get it. And so, as a lawyer, you see that, and a big red flag goes up. But in this context of this Freedom of Information request, we thought, okay, they took extra time to vet it. We've seen this before, and they've given it to us. And not just that, it was a case that was already resolved. It was with respect to one of our own decisions. And we looked at it and we thought, wow, well, this is very interesting. This is what we've known for a long time. We've never really had the evidence to be able to establish what we want to establish. But here it is. And what are we going to do with it? And we thought, we're going to wait. We're not going to do anything right now. We're going to think about how we're going to use it. We're going to pick the right case to use it in. So we didn't do anything with it for a few weeks' time. And we just sat on it, and then we decided that we were going to use it. How we use the disclosure. We started to use it in hearings. We used it in two. In a hearing to argue that decisions were not being made on the merits of the facts of the case, but rather the decisions are reverse engineered by making unsupported factual findings. This pattern indicates that the adjudicator does not make the decision, and that the Freedom of Information disclosure that we've got was supporting our evidence. That was basically what we were going to use it for. We felt that it was very important material for a number of reasons. It was important both for the purpose of defending our clients, but we also thought that it was, and still do, that it's in the public interest to know how these tribunals function. In any event, we used the disclosure, and a few days later we got a phone call from a lawyer from the government. A lawyer for the government was saying, okay, we're asserting solicitor-client privilege over this. This is confidential. It's between a lawyer working for the government and a department of the government with seeking legal advice. When Kyla got that phone call, she said, oh, okay, all right, well, I'm going to delete it. I'll delete the electronic version. I'll tell everybody else to delete it. I'm going to hold pat, she said. I'm going to hold pat on my files, because she'd submitted this in disclosure to the superintendent's office, and these was her client's cases. She couldn't just go destroy evidence in a client's case. It's been submitted back to the tribunal, which presumably would be the ones who could waive privilege and already assume, we would assume know what's in that package because it was advice to the tribunal at a previous time. But so she told them that we would destroy it, and she came to my office and said, Paul, you got to destroy this evidence. And I put my head in my hands. I oh God, okay, so I deleted it. I can't believe this. I deleted it. I went home that night and I'm laying in bed. It's about 3 a.m. I'm back and forth. I can't believe it. I've got that. And I realized you have to triple delete. So I went in the next morning. We thought we better get some legal advice. We better find out what we're doing with this thing, because we've still got these copies that are in the client's files. Now we probably can't use that. There's the one that's in my trash bin. And I think we've got something that's more than just what we're looking at here. I mean, I thought to myself, is there a crime being committed here? And I wanted to research that. I thought it was, I can't, I'm limited in what I can tell you because of the Court of Appeal decision, but I can tell you that I was upset enough that I felt that we had to get legal advice, take a different position on where we were, for the benefit of our clients, for the benefit of the justice system, for the benefit of the perception of the justice system and confidence in the administration of justice and the public. So we then got legal advice, and we wrote back to the government and said, well, look, we think you've waived privilege for a number of reasons. Went through your FOI process. Basically, you're seeing now that we have a use for it, and you're retroactively trying to say that you didn't want to give us this stuff. And we also said, we don't think you're entitled to privilege here because you're doing something that you're not permitted to do. It's outside of the context of legal advice. It's not legal advice, in fact, at this point. The rest of it is, but, is really I don't think of consequence to them. I don't think they cared about the rest of the discussion. They were only concerned about, a few lines. So they came back and said that they were seeking this, intended to rely on it being confidential. We went back to them and said, well, okay, if this is what you're doing, then we think we've got to get a declaration for the court. So we're going to give you 10 days to file a petition, give us some indication that this is what you're going to do. We're going to have to put this before a judge. A judge is going to have to make the decision. And that's what they did, and eventually we ended up in court. So what's the legal test? It's not magic. It's been determined by the Supreme Court of Canada a long time ago. Solicitor-client privilege applies to any communication so long as it's communication between a solicitor and client. It entails seeking or giving legal advice and is intended to be confidential by the parties. Every time the court creates a legal test, there's always another test to the test. So the test here is legal advice. This is just, you'd think the court's clarifying things? Not so much. Because not everything is legal advice. It is, of course, not everything done by a government or other lawyer that attracts solicitor-client privilege. Advice given by lawyers on matters outside of the solicitor-client relationship is not privileged. Whether or not solicitor-client privilege attaches in any of these situations depends on the nature of the relationship, the subject matter of the advice, the circumstances in which it is sought and rendered. That's the Supreme Court of Canada decision, Regina and Campbell. There's the attachment to the test that sets another test that doesn't give us any real clarity. Give us some examples. Well, unfortunately, when we get to examples later on, the examples they give us don't really provide the clarity that we need. So our view of the disclosure that we received was that it departed from legal advice. We felt that it wasn't legal advice at this point. And ultimately, this case went to BC Supreme Court. It was the Chief Judge of the BC Supreme Court, Chief Judge Hinkson, and our lawyer made a very good argument for us. Obviously, we couldn't make the argument because we were the litigants. And the judge in that case came to the conclusion, I have reviewed the 19 pages and am unable to accept the petitioner's submission, that's the government's submission, that all of those pages entail the seeking or giving of legal advice. I have concluded that the following two paragraphs went beyond the permitted scope of solicitor-client advice and entered the impermissible area of recommending that a particular decision be made on the basis of reasons other than the merits. So, this is a finding of fact made by a judge in BC Supreme Court. His finding of fact is this is not basically what we argued. This is not legal advice. It's beyond the scope of legal advice. Unfortunately, because this is in open court, dealing with a matter of a question of a claim of solicitor-client confidentiality, none of us are talking about it. None of the lawyers are reading in exactly, well, here, look at this, what they say here. They're saying, okay, on line 15, look at this. Isn't that bad? The judge goes, oh, okay, well, yeah, it's not so good. Instead of reading it out, and I keep thinking of the Lionel Hutz, for any Simpsons fans, works on contingency, no money down, where he says, works on contingency, and then he says, no, that's incorrect, puts in a comma, question mark, works on contingency, question mark, no, comma, money down. Well, sometimes you have to explain things, and this was one of those things that I felt that needed greater explanation in the court, but I think Chief Justice Hinkson came to the conclusion that, look, I've nailed it here. Paragraph 41, I say, that's my finding of fact right there. So he was being cryptic, unfortunately. We can't talk about the disclosure. I can't talk about the disclosure aside from the terms that are used in the decision, so I'm really limited in what I can tell you because of the Court of Appeal decision. But at the Supreme Court level, Chief Justice Hinkson was deliberately cryptic. Those were his words in his description of the impugned material due to the possibility of an appeal. Recommending that a particular decision be made could be viewed as cryptic. That was his words. I think it's maybe a generous reading, but of course, the Court of Appeal is going to look at it, and then they're going to put their spin on it, and that is where we end up going here. But I think it was very unfortunate that it wasn't dealt with differently. It could have been dealt in closed court or something like that, but everybody wants to have an open court. You know, that's our whole concept of justice, is that we have open courtrooms. Ultimately, this matter goes to the BC Court of Appeal. I can tell you we had this lovely period of time where we had succeeded in this thing and we were able to use it for our clients. We didn't have to destroy it. He didn't say that we could give it to the media. The media wanted it. They could have just gone down to BC Supreme Court because it had been filed in a bunch of cases. The media wanted to see this disclosure desperately. Judge didn't tell us that we could release it to the media. I think it was implied that it could have been publicly released, but that wasn't our issue. We just wanted to use it for the purpose of our clients. That's why we were doing it. And he said to us, you know, in the end of his decision that we could. The government did not seek any interim order to keep it silent while the matter was before the courts and going to the Court of Appeal, which surprised us greatly. If they were as concerned about it as they expressed and put up this battle that they did, why didn't they go to the BC Court of Appeal and say, look, these guys have this, Chief Justice Hinkson's wrong, you know, it's a temporary injunction, give us an order to stop them from using it and disclosing it and what have you. But they didn't. But they did appeal it. And it went to the BC Court of Appeal. And the BC Court of Appeal was the first decision written by that justice. Unfortunately, he's a lovely man, but I disagree with it profoundly. And it's interesting how it came out, and I'm going to give you a little insight into the life of a litigator. I argue all sorts of things in court, and one of the things I try to do, you know, I've got the prosecutor on one side, they're trying to frame the argument one way. I'm on the other side trying to frame the argument the other way. I'm hoping the judge sees how my argument has been framed. When this thing went to the Court of Appeal, as far as we were concerned, the judge at the Supreme Court level changed nothing in the law. He made a factual finding that this was not legal advice. He applied the law that existed, and the law is that tribunals, governments, in-house lawyers, and their clients are entitled to the same solicitor-client confidentiality, privilege protection as anybody else. I'm a lawyer. I don't like to see infringements on solicitor-client privilege, particularly so because I'm a criminal lawyer, and I've been told many, many things over the course of my life as a criminal lawyer that, thank goodness for privilege, and I can't tell anybody. But in any event, we didn't think that he did anything to change the law, and we didn't think that he did anything to carve out any new, different type of solicitor-client privilege for a tribunal. We just think that he made this factual finding. But when it went to the Court of Appeal, the lawyers for the government were very smart, and they did a good job. They reframed the argument. They said, look, this Supreme Court judge has created a new legal test. The new legal test is for tribunals. And we're scratching our heads going, where in that decision does it say new legal test, and how is there a new legal test? But that's what, you know, was ultimately their argument. In the second paragraph of the Court of Appeal decision, the judge says, well, the question here is whether or not there's a different legal test. Oh, man. Okay, at that point I knew we were gone. They say, BC Court of Appeal, the most important question, so forget all those legal tests. Now this is the legal test. The most important question is when the status of communications from a lawyer is questioned, is whether those communications took place within the context of a solicitor-client relationship. Once privilege has been established, it applies to all communications made within the framework of the solicitor-client relationship. Really? Is that the most important test? I don't know. I mean, there's all these tests from the Supreme Court of Canada. I don't think that's necessarily the most important question. They went on to say, if it's clear something is privileged, the balance of the communications must be assessed in relation to the principle that once solicitor-client privilege has been established, it applies to all communications, all, made within the framework of the solicitor-client relationship. Can't just get your Sharpie out and blot things out. A Sharpie is not going to do it. They sort of repeat themselves here. Once the solicitor-client privilege has been established, it applies to all communications within the framework of the solicitor-client relationship, and that severance of some of these communications can only occur when there is no risk of revealing the legal advice provided by the solicitor. And here's the factual finding. Okay, this is, again, being cryptic and not actually discussing what was said openly in court. In any event, the Chambers judge did not view the solicitor's advice as going so far as to usurp the tribunal's decision-making authority, and in my view, there is nothing in the record that would support such a characterization. I think the Chambers judge did make that finding, but again, he was cryptic and didn't want to say it. And we think that he could have been more forceful in it. They were looking at the record. We don't know what record they were looking at, and I just say that, back to the Lionel Hutz analogy here, because this was not discussed openly in the way that we would like. And this was a particular problem because nobody wanted to read it out loud in court. So, what happens as a result of this case? It's actually, in some respects, a failure of litigation leading to a change in the law that was unintended that causes a problem. Once privilege is established now, it applies to all communications made in the framework of the solicitor-client relationship. If it's part of a continuum of privileged communications, it will probably be viewed as privileged. Problem number one. Lawyers could sandwich otherwise impermissible advice, bookended with permissible advice, so long as it's part of a continuum of privileged communications made in the framework of the solicitor-client relationship. I could give you 1,000 examples, but I think anybody in this room can probably think of somehow something that a lawyer could say in between, okay, I'm going to give you advice on, your separation agreement and at the end of that, and okay, and this is the advice I gave you in your separation agreement, and fit all sorts of stuff that you probably shouldn't put in there in the middle. It seems to run afoul of our role as lawyers, and I'm sure the Law Society would have some view on that. I think that tightening of the rule sets up that as a particular problem. The other problem is problem I spoke of earlier, and that is the requirement that utilization of legal counsel by an administrative tribunal must be in accordance with the principles of natural justice may require that when the parties ought to be given an opportunity to make submissions in relation to legal advice, that advice should be disclosed. An example when the parties ought to be allowed to make submission in relation to legal advice is in relation to advice as to the jurisdiction of the tribunal. Gee, I wish they gave another example. Why didn't they give our example too? Because then we wouldn't have had to go through all of this. But this is the problem. This is the catch-22. That's the catch-22 from Bowie. You don't know what the tribunal's been told, and it's never disclosed to you that they're told anything. You have no idea what's being told in the back room. You can't say. It's not like a provincial court where, the judge just goes to his chambers and he might talk to the other judge down the hallway. They might look up the law themselves, but they're not going any further than that. And that's why there's great confidence in the provincial court as a result. How am I for time? Are we doing okay? I'm pretty much done, but in any event, we've filed leave to the Supreme Court of Canada. The unfortunate thing is we can't really appeal that factual finding. We are sort of stuck with the framework that was set out by the Court of Appeal judges. So we've written our leave. We think we're probably going to get leave, even though it was a panel of 3 judges, not just because they're disagreeing with the Supreme Court level, but we think this is something that is of national importance. And it's of national importance because the Senate and other bodies have recognized that putting things into tribunals can speed things up in the justice system. Not so much a problem in BC right now because we took all of our drunk driving cases and stuck them in this tribunal, but in the rest of the country, all of their drunk driving cases are still in provincial court, and they end up with these delays, and because of the decision of Jordan from the Supreme Court of Canada, now these cases are getting thrown out across the country. So the Senate doesn't seem to look over the mountains, but they're just looking at the rest of the country, and they're saying, well, one of these suggestions is that you can stick things into a tribunal. So we think that that's of national importance. We think there's a fairly good chance that we're going to get leave. Anyway, there's the citation for the 2 cases. Thank you very much, everybody. I hope that was interesting enough. I'm sorry that I can't tell you what was actually in there.
Rather than opening up the floor immediately to questions, what we want to do is move right into Michael Lucas's presentation to you. And then once Brad's finished, then we'll open up the floor to questions for everyone. So, Michael.
Thanks very much. First of all, Paul, there's always a Simpsons reference for everything. The Simpsons is a great source of wisdom for pretty much any issue that passes in the world. So finding a Simpsons quote for that is good. And what Paul's raised are questions about what the scope of privilege is, and that's a very important question. And he's also raised questions, I think, that go beyond certainly probably what privacy issues are here. But, you know, one of the hallmarks of our justice system is that it's based on the rule of law. Judicial independence is a keystone to the rule of law. Tribunal independence is extraordinarily important if you're going to have a system that uses tribunals to adjudicate on legal disputes. So confidence in the public on an independent tribunal system is very, very important. And if there's questions about how independent the tribunals are, that's going to destroy public confidence in the rule of law. And that's something that the Law Society, of course, would be very concerned about, but I think everyone should be very concerned about it. And so I don't really have anything directly to say about what Paul's interpreted on those. Whether or not the Court of Appeal is right on whether that's legal advice or not, I don't really have an opinion. You know, I guess questions could be raised about whether or not and I'm not quite sure this is really the case, but certainly if a tribunal is getting advice from basically counsel to one of the parties, that would be something that I think might go beyond what legal advice is, because there really shouldn't be a solicitor-client relationship between the two. But I'm not sure that's what happened. If that is what happened, though, that might be an interesting question to look at. What I was going to talk about was a little bit more about what I consider to be a fairly significant development in solicitor-client privilege over the last year or so in the privacy context, and that has to do with the Commissioner's power to compel production of information over which somebody has claimed privilege in the course of an investigation. As Brent mentioned, there's a case called Privacy Commissioner of Alberta versus the University of Calgary that was decided last November, where the Supreme Court of Canada came out once again examining privilege and shows how stringently that court will review legislation that purports to pierce the privilege. Section 44 of both FOIPA and PIPA give the Commissioner the power to request a record from a public body or from a person despite any other enactment or any privilege of the law of evidence. And there's instances where, you know, when the Privacy Commissioner is doing an investigation, I mean, generally speaking, the Privacy Commissioner, if you claim solicitor-client privilege, certainly from our point of view at the Law Society, they don't really question it too much. I mean, many times from the face of the record, it's pretty obvious that you're claiming privilege, or why you're claiming privilege. If there is a doubt, and they might make you explain the basis on which you're claiming privilege. But there is a power that if they really have some doubt about it, they could compel you to produce the record to the Commissioner's office for the Commissioner's review to determine whether the Commissioner's office thinks that the document is privileged. As I say, that I don't know how often that happens, frankly, but that power did exist in the Act. So the question is, really, does Section 44 give the Commissioner's office the ability to compel production of a record? Well, on its face, it would seem to. But the Supreme Court of Canada looked at pretty much identical legislation from Alberta in the University of Calgary case, and they concluded that the Commissioner didn't have that power. The University of Calgary case had a delegate of the Information and Privacy Commissioner ordering a production of records over which the university had claimed solicitor-client privilege. They eventually issued a notice to produce records under their equivalent to Section 44, and that section said, you know, that the university had to do it despite any privilege of the law of evidence. So the university refused to and sought judicial review of the delegate's decision to issue the notice. And the majority in that case, and it was, I think it was a 7-2 majority, held that the language didn't require the public body, the university, to produce to the Commissioner documents over which they had claimed privilege, because solicitor-client privilege was no longer just simply a privilege of the law of evidence. It was also a substantive right and was fundamental to the proper functioning of the legal system. It said that the privilege that was engaged here was a substantive privilege rather than simply evidentiary privilege, and that the legislative language purporting to abrogate it didn't demonstrate a clear and unambiguous legislative intent to abrogate the substantive privilege. So it said, despite the law of evidence, you had to provide it, but it didn't say you had to provide it, notwithstanding the fact that there was a substantive law or substantive right that you had to claim as well. And to me, and I mean, it sounds like a fairly fine point, but to me it didn't really come as much of a surprise. I expected that would be the case. It reiterated, in my view, the Supreme Court's very clear development of the law of privilege as a substantive right, one that independently existed of the law of evidence, one that all Canadians had as a result of their rights to get proper legal advice. The court held as long ago as 15 years ago that privilege is a fundamental principle of justice and a civil right of supreme importance in Canadian law. And I think that the Supreme Court presaged the decision in University of Calgary in the Blood Tribe Department of Health case as long ago as 2008. That case was one where the federal privacy commissioner was trying to compel production of records over which the public body had claimed privilege. The commissioner in that case relied on PIPEDA that gave the commissioner authority to compel a person to produce records that the commissioner considered necessary in order to investigate a complaint in the same manner and to the same extent as a superior court of record, and certainly a superior court of record can compel the production of privileged documents. But the Supreme Court said in Blood Tribe that general words of a statutory grant to an office holder don't confer a right of access to solicitor-client privileged documents, even for the limited purpose of determining whether privilege is properly claimed, as that role is one that's reserved to the court. In other words, what they were saying was that express words are necessary to permit a statutory official to pierce solicitor-client privilege. So the argument that was put forward by the commissioner in Alberta and the University of Calgary was essentially that the section that they were relying on was an express power. But one can see, I think, from the decision that the court, how carefully, how particularly the court will parse the language of a statute to determine whether or not solicitor-client privilege is engaged and whether or not it's actually required that you produce privileged documents. Once again, solicitor-client privilege is an evidentiary rule and a substantive right, but the language of the section only dealt with the evidentiary rule. It didn't deal with the substantive right. So Brent has sort of explained in his opening remarks about why solicitor-client privilege is so important, and I won't go through that again except to say that if you're in a system that operates under the rule of law and people have to deal with their legal rights, they need to get good legal advice in order to be able to properly deal with their legal rights. And if you feel constrained about advising your solicitor or your lawyer about what the facts of the case are, because you're concerned that that material might come to some other body that might be interested in it, it's possible that you're not going to tell your solicitor everything that he or she needs to know, in which case the advice that you get might not be the right advice because your solicitor doesn't know something about it. So if people are going to be less than frank with their legal advisor in seeking legal advice, the likelihood that the advice will be inaccurate or won't address the real problem increases substantially. Now, as it's clear, the privilege doesn't apply to every communication between a client and a lawyer. And that's where, I guess, the issues come in with how do you interpret what is and isn't privileged, and that's a tricky point. But it's important to remember that it's the client's privilege, it's not the lawyer's privilege. If a client wants to assert privilege and claim privilege, the lawyer's obligation is to ensure that the client has that right to be able to do it. The lawyer may actually disagree with the client that the information is privileged, but if the client is instructing the lawyer not to release it because the client wants to claim privilege, wants to argue before a court that it is privileged, then the lawyer can't disclose the information. And that's an important point to remember in the context of PIPA, because PIPA applies to law firms. So if the commissioner's office came to a lawyer and said, I want to see some privileged information, and even if the lawyer thought that or some information over which a client had claimed privilege, And even if the lawyer thought that the information wasn't privileged, the lawyer can't produce that information, and somebody has to go and make an adjudication on it. So I guess the next question is, could the legislature amend FIPA or PIPA to clarify the commissioner's power to compel production? So, for example, could they legislate and say that the commissioner can compel the production of the information notwithstanding solicitor-client privilege, which would be a pretty clear statutory provision and express words to say that the document had to be given to the commissioner for the purposes of reviewing the document. I think the legislature could do that, but I think that if they did, that language would be struck down by the courts. While the Supreme Court in Blood Tribe makes clear that express words are necessary to pierce privilege, the same court has said that any statute that purported to do so is going to be read against a very, very stringent test. Essentially, that test is that the legislation must be absolutely necessary and it must no more than minimally impair the privilege. And in a case called Goodis versus Ontario, the Supreme Court of Canada said that was a test that fell just short of absolute prohibition. So when you look at it, the Blood Tribe case said that a different test isn't justified for access to information cases. They said it's difficult to envisage circumstances where it would be absolutely necessary if the sole purpose is to facilitate an argument on whether privilege is properly claimed before the commissioner. The court said that the fact that that would increase the judicial workload wasn't a reason to deviate from the test. And they also said that convenience, in other words, setting up a system that might be a little bit quicker than having to go off to court to determine the issue, wasn't a reason to release information that was subject to a claim of privilege. So if you look at legislation, if the legislature were to say documents could be produced notwithstanding privilege to the commissioner's office, is that absolutely necessary? I don't think it is. If the information is privileged, then the commissioner has no right to it. The privacy commissioner has lots of experience, or the commissioner's office has lots of experience in dealing with documents, but the courts have made it pretty clear the courts are the experts in dealing with what's privileged, despite what Paul might say. So the commissioner doesn't have any particular expertise in determining privilege claims. Processes could be developed to allow the court to adjudicate the privilege claim, so it wouldn't be absolutely necessary for the commissioner to see it. Even if you met that test, though, would the production more than minimally impair the privilege? Well, I think you have to look at it on this basis, that if the privacy commissioner obtains the information, makes a determination that the documents aren't privileged in error, and the documents are then released, then privilege isn't just minimally impaired, it's absolutely impaired. It's lost. And there may be ways to backtrack on that, but it's hard to put the cat back in the bag sometimes once it's out. Moreover, the commissioner has a statutory power to provide information to the Attorney General if they believe that there's evidence relating to an offense. So it's possible that an error by the commissioner's office in concerning whether privilege applies could have significantly adverse consequences for the possessor of the privilege if it was then released on to the Attorney General for an investigation. Those are just some general thoughts about that power. There's some other very interesting things that I think have happened in privilege over the last little while. There was at least one. There was a case earlier this year called City of Richmond and Campbell, where the court looked at the question of settlement privilege, which isn't solicitor-client privilege. It's a different sort of issue. It's where the communications between parties in negotiating a settlement are privileged. But it's a different test than what solicitor-client privilege is, and the court has never held that that's a fundamental principle of justice. It's not dealt with in Section 14. The court made it clear that settlement privilege wasn't part of solicitor-client privilege in Section 14, but then they also said that it wasn't dealt with at all in the Act. And so there were no words in the Act that compelled the production of settlement privileged information. So the court held that it wasn't part of it couldn't be part of a production order. I don't know. I don't think that case has been appealed. So I guess that's what the law is on that. Litigation privilege is another branch. The courts have made it fairly clear for some reason that litigation privilege, despite the fact the Supreme Court of Canada says that it's different than solicitor-client privilege, is actually part of solicitor-client privilege under Section 14. So I think all the tests about Section 14 apply to litigation privilege as well as solicitor-client privilege. But once again, whether litigation privilege is a fundamental principle of justice, I don't know the answer to that, so I don't know whether what I've just said to you would apply to questions about whether or not the Commissioner could compel the production of documents over which litigation privilege is concerned. So those are just my thoughts on this. Happy to answer any questions at the appropriate time, and thanks very much.
So I'm in the enviable or perhaps unenviable position of rounding out the discussion. It is properly appropriate, though, that we are, being that we are the Information and Privacy Commissioner and ultimately the people that everyone seemed to be concerned about. I think we should start off by saying that our office agrees in the fundamental role that solicitor-client privilege plays in the rule of law and the legal system. There's no question as to whether or not it plays that fundamental role. And there's also, in our view, no question of removing, piercing, infringing, or otherwise overruling that privilege. The question is whether or not the legislation that gives British Columbians a right to access public records with certain exceptions and puts our office in a situation where we are to adjudicate whether or not those exceptions have been properly applied, whether those rights are to be taken on faith when one of the exceptions that is applied is that with respect to solicitor-client privilege. So you can imagine we get many requests for access to information. It's the vast majority, or many requests for review of access to information requests. It's the vast majority of the work that are done by our investigators. And there's a litany of exceptions that can be applied to an access to information request. For example, it could be subject to cabinet confidence, or it could be the subject of advice or recommendations to government or a public body. It's very common for the initial access request to have been over-redacted, and then it comes through our investigators, and our investigators look at the information, and they discuss it with the applicant, they discuss it with the public body, and more information ultimately gets released. That process results in the objective of the entire administrative tribunal, administrative law system that our system of law has put in place. It provides for judicial economy. It takes an administrative tribunal that has expertise in an area and puts them in place ahead of the courts, but not in replacement of the courts, to determine those issues. If our office is not able to look to see whether or not the documents that are stated to be subject to privilege are in fact subject to privilege, then we're taking it on faith that the individual who's asserting that privilege is correct. And in many instances, so there's a question as to whether or not our office has the expertise to make that call. Our adjudicators are almost to a person legally trained, and they have obviously considerable expertise in this area and in the area of responding to access requests. But when the individual who's asserting privilege may not have any legal training whatsoever, it just looks to them like perhaps it's legal advice. The applicant is just to take it on faith. I think that's not realistic. So I think the key thing for us to consider is it more appropriate for every single instance where the applicant, the person requesting an access to information, is faced with an assertion of privilege, that applicant should have to take it before the Supreme Court of British Columbia, or that our office should somehow have to take that step. Whether that is more appropriate than having an experienced administrative tribunal act as an intervener, where we can look at the information, determine whether or not it is properly subject to privilege, and then, importantly, I think, not release the documents if we find that it is not subject to privilege, but return the documents to the public body or destroy the documents and order that public body to release the documents. So that there's no question of inadvertent release of documents. If we find that the records were not properly subject to privilege, then it's in the hands of the public body to make the disclosure under order from our office. They can judicially review that order and go before the court. I think that is more efficient, and this is obviously the entire purpose for, not the entire, but the largely the purpose behind the administrative tribunal system is judicial economy and access to justice. It's more approachable and achievable by a lay applicant than the expectation that just because privilege is asserted, they have to go before the BC Supreme Court to have that adjudicated. The alternative would be that we would just take on faith that any record to which privilege is asserted is properly asserted. I think that we can see how that would be problematic for individuals who don't necessarily agree that when the legislature said that the commissioner's powers were to apply despite any other enactment or law of privilege, that the only privilege that they didn't actually mean to apply it to was the one that applies to lawyers. So we have this is a situation, I think, where you have the legal. I mean, I'm a lawyer, and I also believe that my advice is very important, and without I shouldn't have to. I think it's more important than I have privilege, and I believe that my privilege is more important than everybody else's. The advantage that the lawyers have when they make that assertion and they put it before a judge is that they're making that assertion to another lawyer whose entire career is based upon the importance of that legal advice that they've given. We don't find them making assertions around the privilege associated perhaps with counselors or providing mental health advice to victims of violence or what have you, because that isn't theirs. They don't consider that to be as valuable because that isn't their area. So from the general public, I think there would be a suspicion that the only area of privilege that is at risk, or to which they have no way to look behind the curtain, is the one that the lawyers and the judges assert is the most important. Again, I want to say that our office does not question that it is fundamental, and we do not take lightly any determination that something is not subject to privilege. The vast majority of instances, we take it on. We take the word of counsel that the records are subject to privilege. Often, it's quite evident just from the access request that the kinds of records that would be responsive would be subject to privilege. And then, in the few instances where we go farther, we do rely on the description of the records provided by the legal counsel or by the public body. It is only in the very minority of circumstances where we would take the step of requesting the actual records. And we do find that there are errors made. And they don't have to be complicated legal questions like the one that Paul had to face. Sometimes it can be quite straightforward. There can be a record that has its own life and as an existence in a public body, say something simple like some soil test results. And perhaps those soil test results somehow involve get wrapped up in litigation, and they're bundled into a request for legal advice to the Attorney General. So now you have an email going to the Attorney General from a public body, perhaps the Ministry of Agriculture, requesting legal advice around this issue, and what is important for you to understand is contained in these soil test results. Those soil test results attached to that email are, without question, subject to solicitor-client privilege. That email with that attachment of those soil test results would not be disclosable. However, those soil test results have a life and an existence within the Ministry of Agriculture all on their own, nothing to do with the request for legal advice. And if the request is made for those soil test results on their own, then you wouldn't properly apply solicitor-client privilege to that access request. But we do see that happens. Well, this was at one point in time attached to a request for legal advice, so therefore, forever in perpetuity, this record is now subject to solicitor-client privilege. I don't think it would. So these are simple things that we can resolve and we can generally work through in mediation, and I think that's very appropriate. The other thing that I think we need to think a little bit about is what happens when we start to say that despite the clear statements by the legislature that something is or is not included in a statute, we're not actually talking about this other thing that obviously is too important, and if you had meant to include it, you would have mentioned it. So we have I think that I appreciate Michael read the provision that provides us with the authority to request, we believe, to request solicitor-client records subject to solicitor-client privilege. So despite any other enactment or any privilege of the law of evidence, a public body must produce to the Commissioner within 10 days a record of a copy or any record required under subsection 1. Subsection 1 gives our office the authority to compel the production of records. So the inference is that any other privilege of the law of evidence doesn't include solicitor-client privilege. But the very next just the very previous section says, if a person discloses a record that is subject to solicitor-client privilege to the commissioner, at the request of the commissioner or under subsection 1, our power to compel the production of records, the solicitor-client privilege of the record is not affected by the disclosure. So you don't waive solicitor-client privilege when you're compelled to provide a record to the commissioner. It seems odd to me that the legislature would never have intended to provide us with the power to compel the production of solicitor-client privileged records, but then also go on to say, but if you do, and if you are compelled to do so, you haven't waived privilege. This is a significant difference between our act and the act in Alberta that resulted in the University of Calgary case. And we would certainly rely on it to mean that the legislature has clearly stated that when they provide us with the power to compel the production of records, they include records that are subject to solicitor-client privilege. So when I talk a little bit about if we think, so when the courts say, well, you didn't actually say this particular kind of privilege, you just said all of them, then you can't possibly mean the ones that are very important. I think we set ourselves up for some marginal consequences. And I think the recent one that we had that was referred to in the city of Richmond, where the court agreed that settlement privilege isn't included in Section 14. It's not a component of solicitor-client privilege. Nevertheless, in that judge's view, it is so fundamental that if the legislature could possibly have intended to require the production of records that were subject to settlement privilege, then they would have said so. This I think, flies in the face of some very basic ways in which our legal system is organized. You have the common law, the judge-made law that over time evolves based on case law. And then that common law can be trumped by a validly enacted statute of a democratically elected legislature. In this case, we're talking about the Freedom of Information and Protection of Privacy Act. Where you can get into a question is if we think it's ambiguous what that act says. In this case, I don't think it is. I think that any other privilege of the law of evidence and then the subsequent proviso that when we're talking about those laws of evidence, privileges of the law of evidence, we're also saying that you don't waive solicitor-client privilege. So that should trump the common law. That's a principle of the way that the law works, in how our system of law works. Then there is another level above that, which is any statute that's enacted by a legislature can't be unconstitutional. So the argument is that the rule of, or the right to solicitor-client privilege is so fundamental that it can somehow be tied to the Constitution, and therefore any clear express intention by a legislature to provide the ability for an administrative decision maker to just review that, I think is a stretch. That doesn't change the fact that I think you can definitely read the cases to go that way. So I think I just want to take a step back, though, and remind everybody, because we read the submissions of the CBA and of the Law Society and other interested parties to our committee to review FIPA, the Legislative Select Standing Committee to review the Freedom of Information Protection of Privacy Act and the Personal Information Protection Act. We also read the CBA's submission to the Alberta government in response to that commissioner's request that their statute contain more express language in response to the University of Calgary case to allow them to review solicitor-client privilege. And the discussion is always in hyperbolic language. We are using words like piercing solicitor-client privilege, removing solicitor-client privilege, infringing solicitor-client privilege. I think that what we're actually talking about doing is just looking to see whether or not it applies, and if it applies, then we will reinforce that privilege by agreeing and actually requiring that it not be disclosed. Having our office provide that role supports privilege and makes it easier for government and public bodies to assert that privilege. So I think the final thing that I just wanted to mention was that we're spending a lot of time talking about something that happens very infrequently. And our office considers this to be a significant right of the client with respect to asserting solicitor-client privilege, and we would never take that lightly. But to remove the ability for our office to ever look behind the curtain, I think would have a much greater negative ongoing consequence to those seeking to assert their access to information rights under FIPPA, compared to the much more hypothetical and, I think, hyperbolic concern around the negative consequence on solicitor-client privilege if it was removed from if our office retained the ability to review those records. Happy to take questions.
Thank you to all three panelists. If we do have any questions, we do have some time for questions, so I'll open up the floor. We have a gentleman at the mic here.
Hello, good day. Testing. Hi, this is Kevin Cum. I've been using the FOI for news stories for 20 years. I've been blocked by Section 14. I note that the section is discretionary, but as Rob Botterill said, the legislature discretionary exemptions have been in effect converted into mandatory ones, and I wish public interest override could override that sometimes, and we'd have to apply a public interest balancing test on the section as they do in the British FOI law. But my main interest as a historian is the time limits to section. Should we do the section become less sensitive with the passage of time, or just should the commissioner or courts say it should apply absolutely? Because now the FOI law says in federal and provincial says it applies forever, even for centuries, potentially. Not just for criminal cases, but even policy advice. So my question is that if we could amend Section 14, should it apply only for the ongoing litigation or end when all the legal processes and all the appeals end? Also, the legal advice privilege in the British FOI law ends after 30 years, and should we do that also?
Michael or Brad, I think might be best for either of you to handle that.
Well, I can just, I think there's a difference between litigation privilege and solicitor-client privilege. Litigation privilege would expire at the conclusion of the end of the process. So at the last appeal, anything that's subject to litigation privilege, I think, is possibly open. I mean, there's going to be arguments, I'm sure, as to whether or not it's actually also solicitor-client privilege, because I think the two overlap at some degree. So that's one partial answer to your question, is whether or not you're looking for litigation privilege or solicitor-client privilege. The question about whether or not it should expire after 30 years or something, I mean, currently that's not the law. Could the legislature change that? I guess they could, but would the Supreme Court of Canada uphold that? I kind of doubt it on the basis of how they've interpreted privilege. I mean, you have to look at the Supreme Court that says that in order to remain relevant, the privilege has to be preserved as much as possible. So that sort of is an indication from the Supreme Court that this is a pretty absolute concept, and that it's actually, it's not, it doesn't interfere with the justice system. It's actually, it's not an impediment to the justice system, they've said, I think, in Laval. It's a positive enforcement of the justice system. So, I mean, you make a point that's quite valid, I think, in the issue as to, is there a rationale for preserving it over 30 years? But I think on the current law, it is, and I'm not sure that the Supreme Court of Canada would change that. But I guess they could be asked to.
I think our office would enforce the law that the legislature put before us, and if they decided to take that step, other sections do provide for sunset provisions as to how long you are able to provide that or apply that exception. I can see a very significant difficulty with this one, because as has been discussed here, and I think has clearly been supported by the Supreme Court of Canada, the privilege actually belongs to the client, and so you would run a risk that you would have a situation where an individual would still have solicitor-client privilege. They'd still be able to assert solicitor-client privilege over a record, but then if it happened to be in the custody of a public body and it was more than 30 days overdue, that they could go ahead and disclose it. That would be a pretty significant unintended or perhaps intended consequence. That said, our job is to apply the law as it's validly enacted, and if they took that step, then that would be what we would do.
Thank you. We have one further question.
I'm not sure if I have a question or a lot of comment. I wish I would have been on this panel. Nancy Benanger, I'm General Counsel at the Information Commissioner's Office at the federal level. We intervened in the Alberta case, and our language in the federal law is exactly like the Alberta case. For 30 years now, the government at the federal level has been sending the solicitor-client privilege documents on which it's claimed without ever being an issue of information going out in the public domain. A bill has been tabled in June in which the federal government has expressly stated, has clarified the language to make sure that the Information Commissioner can continue to see the documents. So I take a little bit of issue to say that the Supreme Court would quash, because at the end of the day, it's the Supreme Court who said, make your language clear and you'll be okay. And I agree with you, Brad, that I think you're fine with the language. Anyway, that's the position I would take. I've been a federal government lawyer for 20-some years. I have to say that there is abuse of the solicitor-client privilege claim. And so, Paul, I'm with you on your side. I can just imagine what those two paragraphs are saying. Solicitor-client privilege is claimed almost any minute you CC a lawyer. It's, do you want to go out for lunch? I'm invited for lunch. It's solicitor-client privilege. There is abuse, and we have had success at the federal level to have information released that claims that solicitor-client privilege has been claimed on. Think about the cost of paying for outside lawyers. Those are taxpayer dollars. Why should it be solicitor-client privilege at the federal level? So there needs to be some thinking about the role of public service lawyers, and where do you put the limit in a true solicitor-client privilege? I'm not trying to undermine that there is a validity to the solicitor-client privilege, but there has to be some form of analysis, and someone needs to look at it. And I'm not sure at the federal level that the federal court would love to get the 1,000 solicitor-client privilege claims that we get for them to judicially review. It's one thing to say they don't mind, but once we start showing it to them, I don't think it'll work. So anyway, at the federal level, we see it, and now the bill says that it clarifies that we can continue to look at it. Thank you. I don't think I have a question, unless you guys have a comment. Thank you.
Well,
You deserve applause.
it will be interesting to see what happens. I agree. I mean, the legislature, the parliament, can write clear and unambiguous language that compels the production of privileged information. But it's going to be read against a test as to whether or not it's absolutely necessary or more than minimally impairs the privilege. And because the court has held that that's a test that falls just short of absolute prohibition, it's a pretty stringent test, and it'll be interesting to see how they apply it. I agree. Privilege does get abused, and there are issues with that. And the Law Society would take very, very seriously a lawyer who tried to abuse solicitor-client privilege. And one of the few organizations that can actually look at privileged information in the course of an investigation is the Law Society, because it's absolutely necessary, because the only way you can tell if a lawyer is competent or is discharging their retainer ethically is to examine what the instructions that the client gave to the lawyer. So there is a power for the law societies to compel the production, and sometimes that's put on the basis that the lawyer is standing in the shoes, the law society is standing in the shoes of the lawyer in the investigation. So the privilege is, you're within the envelope of the privilege. And sometimes it's explained on the basis that it's absolutely necessary for the Law Society to be able to do that, because if they couldn't, then the government would have to, and that would be a violation of the independence of lawyers, and that would offend the rule of law. So you got to hope that, and we expect, lawyers, to, if a client comes and says, I don't want to produce that information because I'm claiming solicitor-client privilege, the lawyer needs to have a full and frank discussion with the client about whether or not privilege really applies in this case. But if the lawyer or if the client says, I don't care what your advice is, I'm going to go off and claim privilege, the lawyer can't produce the document. The lawyer has to resign from the retainer and hope that someone else can prevail better, I guess.
Yeah.
Okay. And you will have the opportunity to talk about this during the break, which we are in right now. I just want to thank our panel, and I would ask you to give them a big hand. This has been amazing.